Good evening, everyone. I'm going to call the meeting to order at 5:32 p.m. I thank you for your patience as we get started. I'd like to do a roll call. So present, we have Scott Waligora. Present, we also have John Tutenhoff, Stephen Isaacson, and sitting in as acting chair. Okay, Mr. Matthews. The meeting has been properly noticed and posted according to law. And we will now move on to item number 2, which are the approval of the meeting minutes from the December 11th Board of Appeals meeting. And I will turn it over to you now.
Thank you. Board members have all received those minutes. Are there any suggested revisions or comments to those draft minutes? Hearing none, the minutes will be approved as submitted. And we can now move on to an attorney review of the standards by which the board must abide. And we have two separate items tonight. And I think it would be helpful if Attorney Bayer would review the standards regarding a special exception that's requested in first item of business that we'll shortly take up. You're going to handle that?
Thank you. Attorney Worth, can you bring your microphone closer to you? Thanks. No.
Property from certain zoning ordinances that require coverage of land on their home on Lake Bluff. Standards that you will be reviewing. What I can tell you is that the Design Review Board reviewed the application, recommends approval. Staff reviewed the application, the circumstances, has no objections to approval. Standards that are in effect are that the exception will have on the appearance and character of the applicant's property, adjacent properties, neighboring properties, the effect that granting the exception will have on the value of the applicant's property, adjacent properties, neighboring properties, whether the granting of the exception will serve the public interest in improving and preserving the value of the property, and other such matters as the appeals may wish to consider. At issue here is the applicant's presentation that they have an attached garage. At the time it was constructed, it was deemed an accessory building and not counted against square footage coverage for the lot. Since that time, the village has adopted the policy that if it's connected, it gets counted towards the square foot lot coverage. So the applicant is requesting, and the board must order special exception to that order.
Does anyone have any questions they'd like to ask Attorney Worth regarding those comments and the standards applicable to the first agenda item tonight?
Wait.
Yeah. I'll recognize you in just a moment, sir. Okay. Any comments or questions from Mr. Worth? All right. That being the case, then I'd like to take up the second agenda item, which is, as noted, one moment. I can't open that right now. So 1 minute, please. Just 1 minute. All right. It's a request for special exception per Village Code, Section 535-34A sub 1 regarding lot coverage at residential property of 2521 East Lake Bluff Boulevard. We've heard from Attorney Worth, and as evident in the packet of materials that we received with the agenda, that the Design Review Board has given due consideration to this project and has no objection to it. In fact, they're recommending that the exception be approved. Likewise, village staff has also reviewed the matter and indicates that it has no objection to the special exception being approved by this board. The board members want to be heard on the issue of the special exception? Okay. And hearing none, is there a motion regarding the request? I'll make a motion that we approve the request for the special exception for Village Code 535-34A1 regarding lot coverage at the residential property located at 2521 East Lake Bluff Boulevard in the village of Shorewood. Is there a second?
Second.
And seconded by Mr. Isaacson. Any discussion of that item? So you had your hand up earlier in the back. Were you wanting to be heard on this particular item? Just one second. I'd ask you to step up to the microphone, please. And we have a procedure we like to follow at these meetings. I don't think you'll find it too onerous. Speak directly into the microphone if you could, please. And I'd like you to raise your right hand. The clerk will swear you in.
Do you affirm that the testimony about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address, please.
Al Letourneau, 2510 East Lake Bluff Boulevard.
Okay. Thank you. Would you go ahead and make your statement?
It's a question, not a statement.
Okay.
And I guess if I understand the proceedings here correctly, it's essentially reclassifying the attached garage as being part of the house, and therefore it required an exception. And you're approving the exception. It's no material change to the dwelling, no visible change to the architecture of it. It's just reclassifying an existing building that's been there for a couple of years, actually. Is that the nature of the request?
I think that there's a application, interior and construction.
Okay. Great. I'm a little bit confused by why people from the neighborhood were invited to take part in a conversation that doesn't modify the appearance of the building in any way, but hey, thank you. And I'm always delighted to take part in these things and happy to be a resident of Shorewood. Thank you.
Now, it
Does the
is
board-
my
The
understanding,
board
though-
can also ask the applicant
yeah.
request.
And before I do that, I'll certainly give you folks an opportunity to be heard on that. It was my understanding from reviewing the submissions that in fact, the side of the house that I'll refer to as you're facing the house, the east side, is where the change was intended, and that in fact that was going to be bumped out a bit. Isn't that right? It's not just going to be interior. So why don't one of the applicant representatives step forward?
Small point of order.
Yeah.
We've got a motion and a second on the floor. So do you want to rescind that and then hear from the applicant and Inspector Burris?
Yes, and that's probably an oversight on my part, since I usually don't sit in this chair, and I have apparently overstepped the procedural bounds of doing so. So,
You look good in the chair, though.
Yeah.
well, appearances are about 90% of success, I'm told. So, with that being said, let's back up a bit, maybe not be procedurally a terrific move, but I'll rescind the motion at this time to allow the applicant to be heard. So would you state your name, please, sir?
Paul Geeson.
And would you raise your right hand to be sworn in by the clerk?
Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Why don't you describe the project briefly
Okay.
for us? Because it appears that at least one neighbor might have misunderstood the nature of the process.
So we are in fact adding onto the front of the house, roughly 100 square feet to the front of the house to accommodate a second ground floor bedroom suite to accommodate an ailing family member. The ordinance we ran into, the house as configured with the garage included towards the square footage of the house causes that proposed addition to exceed the 30% maximum lot coverage for a primary structure. So that's why we're here, to get that special exception to that 30% maximum lot coverage.
Okay. Anything further you'd like to add?
No, but I'm happy to answer questions.
Anyone have any questions for this witness? No. Anyone else here on behalf of the applicant that would like to be heard? No? Okay. Thank you very much.
All right, you're welcome. Thanks.
Mr. Burris, would you like to be heard on this matter? Anyone like to be heard from the building inspector?
Yeah. How much does it exceed? Yeah.
Thank you. Can you raise your right hand? Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So help you God?
Yes, I do.
Thank you.
Yes. So when the house was constructed in 2020, at that time, the attached garage was considered an accessory use and was not counted towards the 30% of the principal building. And so the house presently is legal non-conforming. Since that time in 2020, the village has made the determination that any manner in which a garage is attached to a house, whether it has living space above it or not, shall be computed as the principal dwelling. And so again, the house right now is legal non-conforming. It's over 30% right now. And so it is only going to increase that non-conformity by 1.1%. And the only other things I'll add that here are in the memo, let's see, the property has no other accessory buildings on the property. And the requirement of 30% green space is exceeded by 18% with the proposed addition. So green space, there was a zoning review, everything else is compliant. The house is legal non-conforming, and they're just looking to expand that non-conformity by 1.1%. Okay.
Any other questions? Okay, thank you, Mr. Burris. Any further discussion of this issue by the board? All right, so let's go back. Excuse me. I would again make a motion to approve the special exception requested by the applicant per Village Code 535-34A1 regarding the lot coverage at the property located at 2521 East Lake Bluff Boulevard. Is there a second for that motion?
Second.
Any further discussion? Are we ready to vote?
Stephen Isaacson.
Aye.
Kevin Matthews.
Aye.
Scott Walligora.
Aye.
John Tutenhoff.
Aye.
Motion carried 4-0.
Thank you, folks, for coming. Let's see. The next item of business to come before the board tonight is item number 5 on the agenda. We're reconvening in effect for further consideration of George Washington 1776 Lodge 337's appeal of the denial of its commercial occupancy permit. As noted in the minutes that were approved earlier when we were last here, there was lengthy discussion from both sides on this issue, and documentation was submitted at the time of that last meeting, and some submitted later, specifically some information that Attorney Tomzik had included with an email that was not part of that email when it was disseminated to the board members. And based upon that situation, I moved to adjourn the meeting so that the board would have an opportunity to receive and review that information. And so here we are tonight, having had the opportunity to do so. And the matter now comes once again before this board for decision. I think it would be appropriate, first of all, to have the village attorney once again review the applicable standards regarding this matter that will govern our decision-making process. Mr. Worth?
Absolutely. What's before the board this evening is essentially an appeal that staff misinterpreted the village ordinances in denying the commercial application for the use of the property by what I'll refer to as the lodge. Not an application for a variance. This is not an application for a special exception. This is essentially an assignment error. The board heard from both the applicant through its attorney and village through its attorney. Materials were submitted. I can summarize the arguments if you want, but there is probably a preliminary meeting that the board should consider. It closed the record before adjourning last December 11th. Since that time, both the village and the applicant have submitted additional written materials dated yesterday and today. So the board needs to consider whether it will reopen the record to accept those materials. First and foremost, nothing real controversial about them. The board can review them, but they are essentially summaries of the arguments. If the board opens the record, the board can then also permit either the applicant to make a few follow-up comments and then the village's attorney to make a few follow-up comments, and then that's probably what the board. It's going to accept the written materials, which best it probably should for completeness of the record. Then it'll have to reopen the record, accept those materials. The board feels it's appropriate, solicit additional comments, then close the record and begin.
Okay. Do you believe, before we can discuss that, a motion would be required, or can we just discuss that issue of whether or not those materials will be accepted? The record reopened for that purpose.
Yeah, I mean, I don't know the Robert's Rules of Orders with respect to that. I do know that the chair closed the record last time, so I would assume the chair can open again. But if there's objection by any of the board members, that and not.
So the first question is, I read it. Did I miss something? There's no new information. Statement. What we heard back. Some additional.
Stephen, can you put your mic? Thank you.
Is this, if we, let me just say what I just said. Is the information that was submitted recently and via email, the letter from the village attorney, the letter from the representative's attorney or the property's attorney, is there anything materially different than what we heard last time? Or is it just a restatement of what was heard last time.
And the first part of my letter says, we object to this coming forward.
Rich. Here again. The applicant has the duty to set.
Yes, sir.
The appellant. In these cases, it's the duty of the appellant to set the table and submit any documents it wishes for this body to evaluate on the appeal. Okay? They didn't do that. They didn't submit the emails that they decided they wanted to submit during the middle of the hearing. I graciously agreed to allow them to do that. We were here almost a month ago. I stipulated to that out of courtesy. Since then, again, this is just, a few weeks back. Since then, we've had we've had the holiday season in there. I personally, a couple of times, have gone through whatever viruses were going around. So by the time I made it back to the office, had an opportunity to say, okay, here's the additional emails that they're relying upon as that relates to the arguments. Had an opportunity to look at that and evaluate it against what had been submitted before. All I did was lay out in writing what my response on behalf of the village would be. And I did that. And normally, again, when we put the packet and materials together, we normally do that the day before. I tried to hit that. I think I sent it out around almost exactly 24 hours ago, around 5:30. All of the exhibits that are referenced therein were offered the first time around in the first hearing. There's nothing new. There's no supplementation of the record. I essentially reshuffled the deck and said, okay, based upon, does it make any difference in relationship to what they're arguing now versus what they were arguing before in relation to this email relaying, that had questions about essentially what were accessory uses versus the principal uses. And I laid that out in writing. So I would submit to you two things. That was appropriate, and there's nothing new there. I didn't submit any new exhibits. I didn't submit any new authority that we didn't talk about the first time around. I basically took the opportunity to say, okay, they've asked to supplement the record. They've asked to come back. We're not in any different place than we were before. I thought it would be convenient for the body to put that in writing. I thought it would be easier to follow. Given the fact that we've had essentially, this is the second hearing on this matter now, and that was lengthy argument on the first go around, I thought it was possible that the body might take it under advisement or go into closed session or whatever. And I know we have some people missing. I thought the appropriate thing to do would merely be to put it in writing for ease of use of the members of the body that are analyzing the issues. But again, I would maintain that it's not a supplementation of a record. It's merely a summary of the arguments we would make. It was the appellant that asked to respond or supplement the record because they had made an initial decision not to include that as emails when they set the table the first go around. We stipulated to that, and this is merely summarizing the arguments in response. So again, I don't see it as a supplementation of the record. It's merely the arguments that a free framing of the arguments and reiterating of the arguments based upon the supplemental evidence, and that's it. So that's my position on behalf of the village.
Okay. Ms. Tomczyk, may it be heard?
So the record was closed. The October 20th letter that we submitted had been submitted to the building inspector. I think when it got forwarded to this body, it just wasn't included as an attachment, but it was in the record. We didn't ask for anything supplemental. The record was closed. Yesterday at 6:06, we got the 8-page brief from the village. If that's the way we wanted to proceed, there should have been a briefing schedule. We should have had equal opportunity for both sides to present everything. So once again, this is evidence of the unfairness in this process that's treating my client differently than similarly situated applicants. It's not proper. The record had been closed. We had no notice that this was coming. And if that was the way we wanted to proceed, we should have agreed to that.
Okay, thank you.
I do think there might be a couple other people trying to get in online. Not yet.
Okay. Thanks, both counsel. Does the board have any comments or questions about whether or not the brief submitted yesterday by and on behalf of the village or the letter, a responsive letter from Ms. Tanzik, whether those should be, the record should be reopened and those admitted into the record for the purpose of this proceeding? Any discussion on that?
Yeah, I think that that's sufficient. I think we need to add anything into the record, but I still have a lingering question. Explain it to me again. What are we doing here? This is not a variance. Why is this matter before us? Should the matter not, because I know the arguments. I read all that. Heard it last time we were here. Why isn't this matter before the village council, some other body? Why is it before the board? Because it doesn't seem to fit in our purview. Is that correct?
Well, I'll take a first crack at
Okay,
that.
absolutely,
And then Mr. Worth, as counsel, will certainly correct me if I'm off base on this, but I had that same question at one point along the way, and I think that it's here because under the powers of the Board of Appeals in section 535-55, it says the Board of Appeals shall have the following powers: errors and interpretations. And if I could just keep my computer from acting up. And there it says to hear and decide appeals where it is alleged that there is an error in any administrative order, decision, determination, or interpretation of zoning districts or other code regulations. So I took that as the jurisdictional basis on which this matter could come before this board, because it deals with zoning districts and certainly code regulations relating to that. Is that reasonably accurate, Mr. Worth?
That is exactly correct. The board's authority in this kind of application for review is to take the terms of its code, take the review that was performed by staff in consideration of the application for the permit, and determine whether there was an error. Not to question the construction of the statute. It's to apply the statute or the ordinance. It's to apply the ordinance as it's written, understanding the interpretation performed by the village, and determining whether there's an error. Your powers are to reverse the decision, affirm it wholly or partially, or direct any modification that you may decide would allow the permit to issue. So it's not an application for, not a decision on a special exception. It is literally a consideration of the applicant's assertion that there was an error made, interpretation of it. So that's your jurisdiction.
All right. Any other comments regarding the issue of whether the record should be reopened to allow the two most recent submissions into the record? Anybody else want to be heard on that on the board? All right. I think earlier it was suggested by Mr. Worth, since the chair at the original meeting determined that the record was closed without motion, that the chair at this meeting would have similar latitude. And simply for the purposes of completeness, I'm going to order that the record be reopened, that the brief submitted by the village yesterday be admitted into that record, and the responsive letter from Ms. Tomzik dated today be admitted in the record, and those two items being admitted, then the record is to be closed. Evidentiary record.
What I would suggest is that having made that decision, having reopened the record, board also consider, board has already elicited some commentary, and whether there's any additional commentary. And then the third thing is whether the, having done that, having reopened the record for this limited purpose, whether the board believes it can proceed tonight. additional.
Well, or so just let me just restate what you just said. So the only thing that we would be voting on is whether the village was in error in their judgment relative to the existing ordinances, codes. And that if we vote on this, so the vote is really to decide whether that's true. It has nothing to do with the merits of whether there should be an exception granted for the use.
Correct.
We're not here to discuss use. We're here to discuss whether the village acted correctly,
Interpretation of the ordinance.
interpretation of the ordinance, which is a totally different matter than whether, based on the presentation, the highest best use of the land. What you're saying is that question is not in our purview. That question may belong somewhere else.
Correct.
And do the applicants agree to that? I mean, is that your understanding that that's why we're here? Not to vote on the highest use of the land?
We certainly understand that what we're proposing is a different interpretation of the code. Under our interpretation of the code, we think you have authority to interpret the code to regulate uses, not the user, which is what the village is arguing, that we regulate the user. And within that, there is authority for you to find that there was an error made by the building inspector or the director of planning, and then issue the occupancy permit, because we think this is still office event venue uses. That's what we're proposing. Those are permitted principal uses. And to find otherwise would be to be regulating the user as opposed to the use. But-
So the village's objection, I'm still trying to understand this, is that you have a fraternal organization that's proposing to take this over. That's within the purview of the code. It's how you are not holding meetings of your fraternal organization. That's what disqualifies it?
So the community, get the proper language. So what the village classifies our use to be is a community assembly. And in the code, there are two sentences that describe what a community assembly is. The first one talks about uses, meetings, senior center. None of those things are things we're planning to do. The second sentence does say may include a fraternal organization. However, fraternal organization is not a use. It's a user. And the village cannot apply its code to be treating users differently.
So if the fraternal organization had a monthly meeting that was posted, does that qualify? Well,
I think that meetings could be had either for office use, which is what we propose, or for a community assembly, either one. This is a close call. It's an interpretation issue. I don't think there are that many precedents. I don't know that there are any precedents in the village. So why not find this in a way that does provide the highest and best use and avoids any of the other arguments that might be problematic for the village?
my concern, I'll just, because I came here to state this, whether I vote on it or not, but my concern is that going back to best use, which you presented the last time, which took to heart, is that it appears to me that the developer who bought that piece of property should have waited until they decided whether it was feasible to actually buy it. So they own the property. They've subsequently decided that it doesn't lend itself to the kind of development that they want to do, which I think was residential. So it really now falls back to some user that can meet the standards of the village and have a commercial use that would fit on that space. But the building has been vacant for a number of years. I am concerned, and I'm going to state this, that if this does not get resolved so that there is a use, we have one in front of us, that piece of property could wind up abandoned at some point. And then the village would have it on its hands to take it down, which would cost us money. So just from a business standpoint, it would seem to me that we have a good use, we have good tenant or a good owner that will live within the standards of the village. That's where my head is, but legally, I'm back here on the, does this belong in the purview of this board? And are we deciding whether the objection was correct or not? So in my view, the objection was correct, but the other view is that, is there a way in which the use can conform so that this transaction could go through? Because I don't really want it sitting out there in disrepair at some.
And there is a way for you to do that tonight, which would be to find that our use is not community assembly. It is office and event venue, which is what we've committed to do. And which is principal permitted uses, not subject to locational restriction.
So then going back to the objection of the village attorney, could he restate his objection? Is it strictly administrative, or is there something beyond that which goes to use? Could we consider it?
Can I just ask a question? Are we, I mean, it says community assembly includes fraternal organization. Are we debating whether or not the village read that correctly or
Principal use.
are we talking about whether or not the code is right or
Principal
wrong?
use.
Principal use.
I mean, it seems,
Are you clear, Mr. Bear, on what Mr. Isaacson is asking you to clarify?
I believe so. And first of all, very much appreciate the questions about where the line is and what the jurisdiction of the body is. And I absolutely understand Attorney Tomzik's arguments about, hey, what are we looking at with respect to this property down the road? You know, might there be a solution that's better than what we have now? And those are all valid, reasonable things to talk about, just not in this venue. Just not in this venue.
That's my point.
That's that's the problem. And again, those are all wonderful things to talk about. But here's the 30,000 foot view, right? Is the village itself spent months and years with an outside consultant, many public meetings where people came and spoke, and they made a policy decision as to what the districts should be, right? They decided, you know, GX2, MX1, all these different districts. If you look at 535-25, and you look at all the different types of principal uses and accessory uses that are allowed in all these different areas, that's the policy-making end of it. This body has very limited jurisdiction. It's to say, okay, as written, not policy, but as written, did the planning director enforce the code as it's written? That's it. That's the beginning and the middle and the end of it. And if you think, I'll give you a specific example. If that wasn't the case, if this body had jurisdiction to say, yeah, we'd like to replace, even though the village had months and years of open meetings and worked with a consultant to nail down what its zoning code would be, we're going to replace our own judgment over that. That would create legal problems for the village moving forward, because there would effectively be no zoning other than what this body felt and the members that were there on any given night. And that's not what the law is. That would actually run us into problems, because there's actually case law that says that once, you know, if you make an application based upon existing zoning, you have a property interest in that. And if somebody pulls a rug out from under you, you've got problems. So that's part of the reason structurally the Board of Appeals is set up for limited jurisdiction. And there has been arguments that were made, and I respect those arguments. I understand why they were made. And maybe there's a point to be had with the village board in another venue to try to persuade them to change the zoning or change the designation or make a special exception under the code. There's a time and a place for that. It's just not here. It's just not here. There are some other arguments that were advanced earlier that I also want to address that are beyond the scope of what this body can and can't do. There was the insinuation made that, well, they can't possibly interpret the assembly, public assembly, to include fraternal organizations because there's a difference between use or this or that. What they're really arguing there is that there's a fundamental underlying problem with the code itself. They're challenging the legality of the code that the village board passed. I disagree with that. I think it's clear as it's as clear as it could possibly be. These kinds of regulations are not uncommon. The language is similar. We work with our consultants. It's similar to language in other codes. There's nothing unusual about this. But my point is that insinuation that we might sue you because your code, we think it improperly restricts the user as opposed to a use, and that's discriminatory. You shouldn't worry about that. It shouldn't enter your mind because that is not the venue for that argument. That is not the venue for that argument. And the other insinuation there is to suggest that there's some religious affiliation here, and we might sue under federal rights. We might assert a constitutional violation related to religion. We looked together at the last hearing, excerpts from their website that said we are not a religious organization in any way, shape, or form. But setting that aside, federal courts, and to some extent state courts that have supplemental jurisdiction, are the venue to make those arguments. They're set up. There's a discovery process that lasts weeks, months, or even years. Depositions are taken, motions are filed. There's a judge who's been appointed to the federal bench that has experience evaluating, interpreting federal case law, federal statutes. That's the venue for that argument. This body is not equipped to do that. And if you look at 535, Chapter 10, which lays out the Board of Appeals jurisdiction, it's very clear. It says two things that are relevant to this inquiry. One is that you're limited to saying, hey, as written, is there something wrong with how these people applied the code? I think we're all on the same page. The answer to that is no. And there's one other thing that 535 says, and that this body doesn't have the ability to grant use variances. That's extremely important. It doesn't have the ability to grant use variances. So if you might be persuaded by, hey, that makes sense, I can see the developers made a go of it. They don't have, they haven't been able to. Maybe this is a good solution. And maybe it is. I don't know. But that's a discussion to be had with the village board and in a different venue, right? Not, this body doesn't set policy. That's the problem with that argument, right? And so again, very respectful of the arguments they're making, very respectful of having that discussion in the proper venue. I thought it was a very well presented presentation. There was pictures, there was history there, and I get all that. And that's for another venue at another day. It just isn't what we're doing here tonight. Now, in terms of what is the central question then? What are we doing here? We know that under 535.25, there's principal uses. It seems that there's no dispute that one of the restricted principal uses is community assembly. And we've looked at that. There doesn't seem to be any dispute on that. And here's where the rubber hits the road. I respectfully disagree. This is not a close call. It's not, it says it clearly. 535.25E2, the definition of community assembly in the Shorewood Code includes fraternal organizations. Fraternal organizations. Okay. We looked last time at the exhibits. We downloaded some of the things from the website. What is the Freemasons? What is Freemasonry? Freemasonry is the oldest fraternal organization in the world. That was Exhibit F. Exhibit G, Freemasonry is the most widely recognized fraternal society in the world. The application says, I think we looked at a photo of it the last time we were here, which is the old fraternal lodge from Whitefish Bay, what they're going to do. And the application is, to their credit, is honest about it. It says, we're going to move our fraternal organization, our old lodge, from Whitefish Bay to Shorewood. That they were open about that, and I appreciate that they were open about that. So the inescapable conclusion is that the definition of community assembly in Shorewood's code includes the use of the property by a fraternal organization. There's no way around that. If you disagree with that, or you don't think that's appropriate, you don't like it, that's a different discussion for another day. But the only thing this body can do is apply it as written, and that's exactly what it says. There's something else I don't think is disputed. Community assembly is the principal use proposed for this Wilson Drive property. And the occupancy permit application, again, makes that clear. Now, this is where the rubber hits the road on the other things that they've offered. And I understand why they're talking about these things. But the code talks about accessory uses. And those are uses that are subordinate to the principal use of a lot or parcel, serving a purpose customarily incidental to the principal use. Okay, so let's talk about what the proposed additional uses were. They included office space, which I submit as a circular argument because it's their own office space, which for the fraternal organization, and hosting special events. And I'm sure there's no disputing that the ability to host those special events, birthdays, graduations, what have you, that's a wonderful thing for wherever they are. It's a wonderful thing for whatever community they're in. There's no disputing that. But here's the problem with that. We're not here to argue as to whether that's good, bad, or otherwise. Here's the problem, is that the code says that the tail can't wag the dog, right? The Village Code 535-6 states this, and I quote, "Accessory uses are allowed only in connection with lawfully established principal uses." There's no getting around here that the principal use is for the operation of a fraternal organization. So if you've ever played Monopoly, and you get the card, it says, do not pass go, do not collect $200. That's where we are. We don't get to those accessory uses because we don't have the principal use that's allowed. And that's exactly what the code says. It's 535-6. And it says use variance. We've already talked about the fact that use variances should not be granted. So again, I do think, that the lodge has raised a lot of interesting questions for the village to think about and possibly engage with the village manager or the board about whether or not there might be an amendment to the code down the road to do something differently and allow a use or work out an agreement. And those are all wonderful discussions to have. There's certainly no doubt that, that something like that could be explored. But that's not what we're doing here, though. This is limited jurisdiction, and this body's job tonight is to simply say, hey, we're going to look at 535. We've got a principal use as a fraternal organization here. That's the principal use being proposed. And we know that's restricted. So the fact that there might be accessory uses is essentially irrelevant because, again, just like Monopoly, do not pass go, do not collect $200. We never get there. And the problem is for the lodge, again, and I wish them all the luck with respect to having those discussions in other venues and maybe they'll be successful there. But all this body can do tonight is look at it and say, under 535-25, do we have a restricted principal use? The answer to that question is yes. And to the fact that there are accessory uses that might otherwise be allowed if we had an acceptable principal use, does that matter? The answer is no. The answer is no. So again, with all due respect to what they're seeking to do, and I wish them, well in their future endeavors, wherever they end up, be it, somewhere in the North Shore, I don't know where, but for the limited purpose tonight, that's all that's in front of this body. And we can't get past that principal use problem. And it's not close and it's not clear. It's a fraternal organization. And that's what the use is going to, primary use is going to be as. And that's the beginning and the middle and the end. So I thank you, and I'll answer any questions that you might have.
So we're getting back into the discussion of operation, which is, as you just point out, is not what we should be talking. We're talking about whether it conforms as applied to the ordinance, as applied. Now, they could change their application to change their operations and represent it, right, for another evaluation? Is that?
Sure. I mean,
They suddenly decided we're going to hold a monthly meeting and have a meeting, post a notice to comply.
Well, anybody could submit an occupancy permit application. But I can't speculate as to what would be in such an application.
But today, right now,
Right,
we don't
right.
have that, is what you're
Well,
saying.
I think what we do have is an application that was properly denied because the principal use fits the definition under the code of community assembly, which includes literally, and I'm not summarizing or paraphrasing or comparing. It's literally, it uses the word in 535-25E2, it uses the word fraternal organizations. So there's going to be, the principal use is going to be the operation of a fraternal organization out of that property, which
That's
is
legal.
Yeah. No, it's not. It's,
That's where I'm confused.
yeah, okay.
The Masonic organization is a fraternal lodge. Fraternal
correct.
lodge is allowed to be in that building.
It is, which is a restricted, the community assembly in the MX2 district, which is what this is subject to location restrictions. It's 535-25A2C. It says uses identified with, and then it has the upside down circle filled out on the top, are permitted, but only when located above the ground floor in the upper stories of the building or in the rear of the ground story, a minimum of 20 feet from the primary facade. The first 20 feet behind the primary facade must contain occupied building space of an allowed use. And then it says C 535-6A for definition of occupied building space. So there's no dispute. We just, it doesn't meet the criteria for that location restriction.
And
So
let
it's
me-
not allowed. Okay.
Let me add this.
Yeah.
Here's what the actual application says. This appeal relates to the Village of Shorewood Planning and Development Department's denial of applicant's commercial development application based on an erroneous classification of applicant's proposed use as community assembly. That's your jurisdiction. Did the planning director err in his classification of applicant's proposed use community?
And the definition of community assembly contains the words fraternal organization, which they are. That's the principal use. That's the proposed principal use for this site.
But where
So
does
that's-
this fail in that application? What exactly fails there?
Because the proposed principal use is as a fraternal organization. It's going to be
Well,
used by a fraternal organization.
I think what your question is, okay, so what? Why can't they go in? This is a secondary use. The answer is, for our code, the secondary use has restrictions on where the operation within the building needs to
Right.
be. Their operations couldn't comply with secondary use requirements.
So it's a configuration issue.
Principally, yeah.
Any other questions from Mr. Bear before he steps away from the microphone?
Thank you.
Hearing none, thank you.
On your question about the locational restrictions, the building is only 30 feet wide. If we would only have the first 20 feet of the building could not be used for this use, there's 10 feet left. So that's the problem with applying these locational restrictions. I'll be brief. We are not asking you to throw the baby out with the bathwater. We are not asking you for a use variance. We are not asking you to ignore your language. What we are asking you to do is to read all of the language in the code, which is the basis of statutory interpretation. You have to read it all. And you also have to respect what we have proposed that we're using this site for. So community assembly doesn't just say fraternal organization. It also says hosting public or private meetings, senior centers, community centers, municipal-owned performing arts centers, religious institutions. Offices and event venues, which is what we think we are general office, just like, and I don't think there's anything inappropriate, despite Mr. Baker's assertion that office use is for the owner's office use. That would be a norm. But event uses are defined, and an event venue is a multi-purpose venue facility hosting special events such as graduations, weddings, anniversaries, holiday gatherings, trade shows, corporate functions, or parties, concert setting, and general get-togethers. It generally includes indoor and outdoor seating, which we do, a stage or event area, which we do, but not a full-service kitchen, which we have a kitchenette, but not a full-service kitchen. We meet the language of office and event venue, and that's what we think we are. And that's where we think the error came into play with the building inspector classifying us as a community assembly when there is another alternative under the plain language of your code. And we're just asking you to apply that plain language in the way that works for what we propose to do at that location. Thank you.
Any questions for Ms. Tomzik? The board? Hearing none. Thank you. Anyone else desiring to be heard on this matter tonight, other than board members? We'll open that up in a moment. No? Mr. Worth, you have any other further directives you want the board to consider?
I don't. I think you can close the record again. If you want suggestions on topics I'd like to see hit during your deliberations, I can give you those. I think you probably know what they are. But I think we ought to close the record, do the deliberations, and if you're able, come to a vote.
Okay. Any comments from the board about those remarks from Mr. Worth? All right, then as chair, I'll order that the record be closed for the purposes of this proceeding. So you had a few other suggestions you wanted to make, Mr. Worth. We'd like to hear those now.
Good. I would like to see the discussion, your thoughts, your exercise of your decision-making on, obviously, the principal use question. This is an assignment of error application, so you'll need to discuss and hash out whether the applicant has successfully shown that the planning director erred when he found the applicant's principal use to be community assembly. I think your discussion and or exercise of discretion and your decision-making also to address whether the applicant has successfully shown that the planning director erred in not classifying the principal use of the building as office. You're certainly not limited to those three, but record ought to reflect it.
I do have a question. Do we have any history of the American Legion that operated there? Were they in compliance, or did they exit before this ordinance drafted? Or
Don't think the record anything with specificity or decades their operation. At least in the record.
That would give us.
Well, but the record does contain information that makes clear that the zoning was changed in 2023 I believe after the American Legion had vacated the premises. So any operation by the American Legion under a prior set of zoning ordinances would effectively be irrelevant to our consideration of this issue.
Is that when was that when the sale of the property went to the developer, 23? I mean, I don't know.
That I
the
don't know,
history.
and I don't think there was anything in the record on that issue. Anybody recall that? But I don't know that they coincided. But because the suggestion was that the building had been empty for 4 or 5 years, if I recall, from submissions by Ms. Tomzik, something to that effect. So I suspect that the Legion may have vacated and sold the building sometime at or around the time the ordinance was changed. That could well be.
So can you, before we vote, can you restate what we're voting on? Just to be clear.
Sure, you're voting on, the applicant has asked that you view and vote on whether denial of their commercial development application was the result of erroneous classification applicant's proposed use. I think within that knife edge decision, discuss on the presentations, your thoughts, decision making on principal use, attendant to the application for the commercial development permit. I think then you need to determine whether planning director erred in selecting assembly. I think you need to determine whether or not the applicant has successfully shown and/or that this applicant has successfully shown that their error not classified as offices.
Was the application for community assembly?
The building application?
Their application.
Address.
It was office and event use, the building inspector assigned without consulting us, the community assembly designation.
What, can I ask you,
Well, the record was closed
Yeah,
previously.
I think you're allowed to ask that kind of question,
okay.
factual question.
Okay. Anyone on the board want to respond to the suggestions of Mr. Worth regarding the determination of the village regarding the assigning community assembly to this, or whether that was an error, or whether they erred by not accepting the designation suggested by the applicant of event and office space, any of those issues?
This is so it is a denial of applicant's commercial development as to the proposed community assembly, correct? And we're just doing it on the interpretation the village had.
It's almost
That was-
it's almost kind of the applicant
Yep.
suggested that its use would be office. Of course, that's fine.
Okay.
How the planning director has to proposal. It is focused on assembly. That's the one. Planning director determined proper classification, determining whether
Yeah. And we're just in board general discussion right now, correct?
Yes.
Yep.
Yeah. And as I'm seeing it, myself, that, he didn't make any type of quick judgments or anything else, it was pretty well thought out. Not I'm not seeing error. I'm not seeing a lot of error in any way, but a lot of consideration to several different merits that we can't actually vote on. But when it comes down to error, I don't see any here on the village's side.
Just add a comment. I think if we're to consider whether the planning director made an error, we'd be looking at whether or not this is and if it was ambiguous, we'd probably debate whether they meet that or not. But I think it's pretty clear.
You heard the debate.
Yeah, it's pretty clear that this is a fraternal organization by their own admission. The codes prohibits, excludes, or defines community assembly as a fraternal organization, whether we like that or not, or it's right or not. So did the planning director read the code and apply community assembly to this fraternal organization? I mean, I don't think it could be any more.
Well, I have a couple of comments following these two considerable hearings. And first one is, it's a very interesting process, and I appreciate the input from the applicant and their counsel, as well as the village and Mr. Baer and Mr. Worth. It's insightful, it's informative, and they answer questions very specifically. So without being accused of blowing smoke, which is the last thing I want to do, the presentations were well done and informative and helpful. So that's much appreciated. My personal view is that the primary issue is primary purpose. And that the words in the ordinance are there for a reason. And community assembly does include all of the items discussed by the various parties, and it includes specifically fraternal organizations. I was not privy or party to the discussions and analysis that went into the adoption of that zoning ordinance, but I have to believe that the words were used intentionally and with purpose. And so that said, I also believe that there is no question that the applicant is a fraternal organization. That's well demonstrated in the exhibits and documents that have been presented. The question then was that notwithstanding the use of fraternal organizations in that section of the code, is there other code sections that are more appropriate as asserted by the applicant, that is office or event space? And that is a tough call to the extent that there's some suggestion of all of those uses. But when I looked at the plan of operations that was submitted as part of this application, I was struck by the very first sentence, which says the primary use of the property will be for Masonic activities serving as the home office and operations base for the applicant, in effect. And goes on to discuss what those will be and when and how the organization meets. And it does go on to indicate later in that document that the building will be made available to the general public for special events. And they go on to list a number of those that mirror events considered under the events section of our code of a zoning code. But my reading of that document is that those are merely ancillary purposes and uses. There was some suggestion, I think, at the earlier hearing that they would look to maybe rent or lease some office space. They hope to do these other activities. And frankly, that was for stream of income purposes. I don't know anything about the finances of this organization, but it was suggested that those types of activities might provide some additional income to the business, to the operation. But I believe those are ancillary. And I believe that the village was correct in its determination that community assembly is appropriate, that it is the primary purpose of the applicant's use of this premise, and that the decision by the village in that regard was correct. Anybody else? Hearing none, is there a motion?
I'll have a motion, well, I'll give a hand at it, I guess. See if I read this right. That propose to deny the appeal and uphold the village's interpretation of ordinance 535. We have to name an ordinance?
I'd probably reverse that and take the motion proposal, if that's the motion you're proposing, to affirm the
To affirm
decision,
the decision?
which would have the effect of denying it.
Okay, so I propose to affirm the village's interpretation of ordinance 535 and deny the appeal. Oh, yeah, it was in ordinance 535. Oh, the village code? Okay, yeah. All right, so I propose that we uphold, or no, what? Affirm the village's interpretation of Code 535 and deny the appeal from the appellant.
Okay. Is there a second? Okay. Any further discussion by the board? Are we ready to vote? Okay, you want to call the roll?
Kevin Matthews,
Aye.
Scott Walligora,
Aye.
Stephen Isaacson,
Same.
John Tutenhoff.
Aye.
Motion carried 3 with 1 abstention.
I believe that's the last item of the agenda for tonight's meeting. And therefore, this meeting is adjourned. Thank you all.
Thank you all for coming on virtually. I am now going to stop the recording and end the Zoom. Have a great night.